Welcome everybody to today's episode of The Law of Self-Defense. Come on in, make yourselves comfortable. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Very, very kind. Thank you so much. So we're here today to talk about a bunch of legal experts in the media discussing stand your ground law. And it is a hot, steaming mess of garbage. I just picked three kind of arbitrarily. They're representative of the hot garbage being offered to the public on this topic. So they should be sufficient for our purposes. All of you in the Law of Self-Defense member chat, just keep in mind, you should put any questions for me there. They're free for Law of Self-Defense members, of course. And by the way, it's easy to be a Law of Self-Defense member. Let me pull my little banner up. You could become a Law of Self-Defense member right now, instantly at lawofselfdefense.com/join. And you can ask all your questions for free. If you're watching this live on YouTube or Rumble and you'd like to get your questions or comments answered, they need to be $5 super chats or $5 Rumble rants per question minimum. Or ask your questions for free as a member at lawofselfdefense.com/join, which is about 30 cents a day, less than $10 a month. $10 a month gets all your questions answered for no extra cost, or $5 a question. You do the math, whatever you think is most appropriate for you. I know what I would do, but that's up to you. So, I also want to mention, what the heck happened here? Let's see. I have more I have to mention, because we have a sponsor, of course, of today's content, and that sponsor is none other than our very own Law of Self-Defense American Law courses. These are our law school level courses intended for normal people who don't want to go through the enormous cost or enormous time of law school, but would like a law school level education in typical first year law school courses. And we're now expanding beyond that as well. But so far we've done criminal law, property, evidence. This summer, May 17th, we have our constitutional law class starting. These are all taught by world-class instructors, masters of their area of expertise. And the summer semester starts on May 17th with constitutional law. I believe in the fall, we're doing business law, for those of you interested in that, as well as criminal procedure, or think of it as crim law 2. And all these courses are taught live. They're first run through. And of course, we record them and make the recordings available as well. If you're interested in being the best American citizen you can be, because you've learned the law at a law school-like level, then I encourage you to take a look at AmericanLawCourses.com. All right, so what do we have? We have three experts brought up by the media to talk about stand your ground law, as if they knew what stand your ground law is. Because as near as I can tell, they simply have no idea what they're talking about. And the big problem, one big problem here is that none of these experts have any apparent particular expertise in use of force law, not even criminal law sometimes. What expertise they do have in criminal law tends to be like financial crimes. Stand your ground's not going to come up a lot in financial crimes, folks. And because they don't really understand use of force law, they're kind of stupidly conflating a bunch of very, very distinct use of force law doctrines. And of course, it creates a hot mess. A lot of this is driven by, of course, the politics of gun control, which is hot in the news once again, and the propaganda campaign being built around prohibiting law-abiding Americans from being able to possess guns. And if they do possess it, having a chilling effect on their willingness to use the guns in defense of themselves or their families. It's about as anti-American as you can get, really. But before we dive into the hot mess that is these experts' opinions on the law, let's take a look at the actual distinct legal doctrines that we need to understand why they are messing things up. Self-defense, castle doctrine, stand your ground, defense of highly defensible property, and self-defense immunity. These are all completely different things, folks. And when you conflate them into a hot mess, you end up with a hot mess. So what is self-defense? Self-defense is simply the legal privilege to use force in self-defense. And it's defined by, of course, the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. In order for your use of force against another person to be lawful, you must have been the innocent party, innocent victim of an unlawful, imminent threat of force that you reasonably perceived and subjectively believed to be necessary. So not the aggressor, that's innocence. The threat you're facing was immediately about to happen, that's imminence. You used only non-deadly force if you were facing a deadly force threat, and you didn't use deadly force unless you were facing a deadly force threat or had some other legal privilege for using deadly force, like defense of highly defensible property. That's proportionality. Avoidance: if you're in one of the rare 11 states that imposes a legal duty to retreat, then you are required to take advantage of a completely safe avenue of retreat before you can use deadly force in self-defense. But in 39 states, there is no legal duty to retreat. They're stand your ground states, so avoidance is off the table as a requirement in an otherwise lawful case of self-defense. And then reasonableness requires that first you had a genuine good faith belief, a subjective belief in the need to use force in self-defense, and that belief was objectively reasonable. So an irrational fear is not sufficient. Those are the fundamental building blocks, the 5 building blocks of self-defense. If you'd like to get this cheat sheet, folks, we do make it available for free. lawofselfdefense.com/elements. And you can download this. It's just a PDF download. Or even better, you might consider getting a free copy of our book, The Law of Self-Defense. And of course, I can't find the banner for that, but you just get it at lawofselfdefense.com/free book. Easy enough to remember. So that's self-defense. And if you meet the conditions for self-defense, then your use of force against the other person was not unlawful. It wasn't a crime. It was legally justified, legally privileged. Of course, more accurately speaking, if you claim these and there's some evidence to support them, then the state has the burden to disprove one of these beyond a reasonable doubt. If the state can do that, they've crushed your claim of self-defense. It's obliterated. But if the state cannot disprove any of the required elements beyond a reasonable doubt, what you did was not a crime. It was a lawful use of force in self-defense. That's the doctrine of self-defense. What's the doctrine of castle doctrine? Well, the castle doctrine says, properly understood, all castle doctrine means is that if you were in a jurisdiction that would have required this element of avoidance, that would have imposed a legal duty to retreat if you were being attacked out in the street, and retreat was safely possible with complete safety. If you would have had that legal duty to retreat out in the street, out in public, you are relieved of that legal duty if you're in your home, if you're in your castle. That's all castle doctrine does. If you're attacked in your home, you're not required to flee your home before you can defend yourself. That's it. That's all castle doctrine does. Doesn't give you special privileges for using force. All it does is take that element of avoidance off the table. So now there's only 4 required elements for the prosecutor to attack instead of there being 5. Avoidance is off the table. What stand your ground? Effectively, all stand your ground is expanding the castle doctrine out into any place you have a right to be. So if you otherwise would have had a legal duty to retreat before you can defend yourself, you're relieved of that legal duty to retreat. Avoidance is taken off the table in otherwise lawful cases of self-defense. Does stand your ground or castle doctrine remove the other elements? Well, let's here stick to castle doctrine. To stand your ground. Does stand your ground mean you can just shoot someone because you're scared? No, of course not. Stand your ground self-defense is the same as ordinary self-defense, except you don't have the element of avoidance. You still have the other elements: innocence, imminence, proportionality, and reasonableness. Understand your ground. For your use of force against that other person to be lawful, it's true you don't have a legal duty to retreat, but you still must have been the innocent victim of an imminent, unlawful attack, deadly attack if you use deadly force in self-defense, and you have to have had a genuine good faith subjective belief in the need to use force, and that belief had to be objectively reasonable. All that still has to be true. Understand your ground. It's not simply a license to kill because you had an irrational fear of somebody. Now, defense of highly defensible property. This is often mistakenly referred to as castle doctrine. That's sloppy terminology. I've explained all castle doctrine does, properly understood, is relieve you of a duty to retreat if you're attacked in your home. But there are special provisions under the law that give you special privileges to use deadly force in defense if you're attacked in your highly defensible property. And highly defensible property always includes your home, often includes a place of business, often includes an occupied vehicle. That varies by state. But essentially, what defense of highly defensible property does is it presumes that some of these other elements, remember, avoidance is already forgiven in the context of highly defensible property under the castle doctrine. So that's off the table in an otherwise lawful case of self-defense. You already don't have a legal duty to retreat. But what defense of highly defensible property may do is legally presume that these other elements are also satisfied. So it creates a legal presumption that if you're defending yourself against someone usually forcefully and unlawfully entering your home, it's presumed that you have a reasonable fear of an imminent, unlawful, deadly force attack. So it's presuming some of these other elements are present in the context of defense of highly defensible property. Now, these are always a rebuttable presumption. If it's obvious that you simply executed somebody in your living room, they're handcuffed face down with a bullet hole to the back of their heads, that presumption will not survive attack by the prosecution. It's a rebuttable presumption, but you're starting with the presumption if you had a reasonable perception that someone was forcefully, unlawfully entering your home. Self-defense immunity. Self-defense immunity has nothing to do with when you are privileged to use force in self-defense. It has nothing to do with defining the scope of self-defense. Those other doctrines do, right? Self-defense itself starts with the 5 elements. So that's the scope of self-defense. That's the circle in which self-defense is permissible. Castle doctrine and stand your ground both remove the element of avoidance. So they changed the definition of self-defense. It's no longer 4 components or elements. It's no longer 5 elements. Now it's only 4 elements. So in a sense, it's redefining what qualifies as self-defense. It's expanding the breadth of what qualifies as self-defense because you no longer have to deal with that issue of retreat. Defense of highly defensible property simply presumes some of the components of self-defense to be present under the circumstances we already described. So all of these in some way affect the definition of self-defense, but not self-defense immunity. Self-defense immunity has nothing to do with the definition of self-defense. It merely says that if your use of force was self-defense, you're immune from prosecution, you're immune from civil suit. However, self-defense may be defined. So self-defense immunity doesn't care if there's 5 elements or 4 elements or 3 elements in your claim of self-defense that are required to be satisfied. Self-defense immunity doesn't care what the definition of self-defense is, except whether or not you qualify under whatever the definition is. If you do, you're granted immunity. So these are each distinct legal doctrines. Even castle doctrine and stand your ground are distinct in the sense that one applies in your home, one applies in public, and they each have distinct conditions. So, for example, let's start with stand your ground. Often, as a condition of stand your ground, it's required that you not be engaged in unlawful activity. So if you're a street corner drug dealer, you can still defend yourself lawfully if you're robbed, and street corner drug dealers are subject to robberies with some frequency, but you may not qualify for stand your ground. You may reacquire a legal duty to retreat. But castle doctrine generally doesn't require that you not be engaged in unlawful activity. You could have a bunch of illegal drugs in your house, and you still don't have a legal duty to retreat from an attacker in your home. So they're all distinct. And conflating these is an indication that the person speaking about these doctrines is literally ignorant of them, doesn't understand them, doesn't understand their scope and limitations, doesn't understand that they're distinct. Sometimes this is just feckless ignorance. Well, sometimes it's just outright ignorance. They just don't know. They've never been properly educated. And sometimes it's just feckless political propagandizing. And it can be hard to tell the difference. I think we do have a difference in the three experts I have today. I think the first two are a combination of ignorance and feckless political propagandizing. I think the third lawyer here is, he appears to be well-intentioned. And most of what he talks about is actually reading statutory language. And it seems to me for the third lawyer here that it's largely the interviewer, the media person herself who's mangling these doctrines, but we'll get to that in just a moment. So those are the five distinct legal doctrines. Let's jump now into the first of our purported experts. And this is from PBS NewsHour. It's only 6 minutes long, folks, and it'll probably take me half an hour to get through this 6 minutes because of what a pile of hot, steaming garbage this is. So that said, let's jump in.
Week, 4 young, unarmed Americans were shot, one of them fatally, over simple, everyday mistakes: pulling into the wrong driveway, ringing the wrong doorbell, getting into the wrong car at a parking lot. These high-profile cases have reignited the debate over self-defense and what justifies the use of deadly force. According to the National Conference of State Legislatures, about 30 states have some form of so-called stand-your-ground laws.
Okay, 30 states have stand-your-ground laws. Let the hot garbage begin. Where the heck is my little graph? Here it is. These are the states that don't have stand-your-ground, folks. There's only 11 of them. 11. That means 39 states are stand-your-ground states. This is not ambiguous. It's just that the people who say 30 or whatever other number don't know what they're talking about. Let's look at this map again. Notice states that are not on here. Okay? Just for illustrative purposes. Do you see Washington State here? No, Washington State's not a duty to retreat state. It's a stand-your-ground state. Do you see Oregon here? Also a stand-your-ground state. You see California here? Also a stand-your-ground state. All liberal states, right? All stand-your-ground states. But look at this idiotic map. Washington, Oregon, California are here listed as duty to retreat states. Colorado listed as a duty to retreat state. New Mexico listed as a duty to retreat state. These people are idiots. These are the only duty to retreat states. So when you see someone present a map like this to you from a purportedly authoritative source, keep in mind there's a good probability that these people are simply idiots. Let's continue with this idiotic video.
They expand on a person's right to use force if they feel threatened. Robert Spitzer is a professor emeritus of political science at the State University of New York at Cortland.
All right, so let's take a look at this guy. This is the first expert, the expert on stand your ground. Stand your ground, of course, is the use of force law doctrine. First of all, this guy's not a lawyer. He's a professor. Second of all, he's a professor at SUNY Cortland. For those who don't know, SUNY stands for State University of New York. So he's a New York professor. New York, folks, is not only a heinous gun control state, but it's one of the 11 duty to retreat states. So already he lives and works in an anomaly state, in an academic environment. And he's not a lawyer. Not only is he not a lawyer, but he's a professional academic gun control activist. His books, Guns Across America, Reconciling Gun Rules and Rights, Encyclopedia of Gun Policy and Gun Rights, The Politics of Gun Control, Gun Control, Gun Control, Gun Control. The guy's a gun control partisan, folks. Plus, there's nothing to indicate he knows anything. None of these books are about use of force law. Not one. So that's who PBS brought on as their expert. Let's hear what the good professor from SUNY Cortland has to say. And by the way, why is he filming in a closet or a hallway? Does he not have an office at Cortland?
His latest book on U.S. gun policy is the...
Look at this, the subtitle, How History is Against Expanded Gun Rights. I guess if you're a Second Amendment absolutist like me, you're on the wrong side of history, folks.
Gun Dilemma, How History is Against Expanded Gun Rights. Mr. Spitzer, there are differences from jurisdiction to jurisdiction in these laws, but what's the general principle? What's the general idea of stand your ground law?
All right, he's going to tell us what stand your ground law is. Let's hear him.
Laws.
Well, there are two parts to the stand your ground laws that are relevant. The first is the general idea that if you're in a public place and you are attacked or somebody is about to do you grievous bodily harm or even to kill you, instead of leaving this public place, if you could do so safely, which is a standard some states have, stand your ground laws say you can stay where you are and resist force with force, even to the extent of killing the other person.
So far, so good. So far, so good. Now, of course, to be clear, stand your ground doesn't really mean that you can kill the other person. That's not really part of stand your ground. Stand your ground is simply saying the element of avoidance is taking away as part of self-defense. Your privilege to kill someone is within the self-defense doctrine, not without the stand your ground doctrine. The stand your ground doctrine simply subtracts the element of avoidance. You still have to meet all the other conditions for self-defense. But in fairness, sometimes the statutes are written that way. Florida does it. They say you can stand your ground and meet force with force, even deadly force. All that statutory language is doing is clarifying that stand your ground applies in the deadly force context.
So that's the stand your ground.
So that's what he thinks is the first half of stand your ground. Let's hear what he says is the second half of stand your ground.
Idea, which itself I think is somewhat controversial in legal circles. But there's an added dimension to this, which began when the state of Florida enacted a heightened stand your ground law in 2005.
How is it a heightened stand your ground law? All right, he just explained stand your ground. I think it's a reasonable definition. If you're out in public and you have an otherwise lawful case of self-defense, you're not required to retreat before you can defend yourself. Fair enough. Let's see what this heightened stand your ground is.
That not only adopted the stand your ground standard, but made it, as they said in the law, an absolute and irrebuttable presumption that an individual who kills or harms another has acted in self-defense and cannot be prosecuted.
Okay, he just quoted what he says is the law, right? Let's hear it again. He's reading here. You can see his eyes go down. I want to hear this quote again. Listen carefully.
It, as they said in the law, and
as they said in the law,
absolute and irrebuttable presumption that an individual who kills or harms another has acted in self-defense and cannot be prosecuted. This
absolute irrebuttable presumption that someone who kills or harms another in self-defense cannot be prosecuted. That's what he's claiming the law says in Florida. Well, I took those terms out of curiosity. I took those terms and I Googled them. Not Googled them. Sorry. I went to Lexis, which is the professional legal database we use in my office. And I searched for the key terms there: absolute presumption, kills and harms. And I looked under statutes, Florida statutes that use any variation of this language. 0 results. There's no Florida statute that says anything like the language he just quoted. Okay, fair enough, fair enough. Law doesn't come only in statutory form, right? Law also comes in case law, court decisions, right? Appellate court decisions. So I thought maybe I should take a look at the Florida case law and see if there's anything in there that at all matches up with the sentence he just read. And lo and behold, 0 cases in Florida. 0, none. There's nothing in Florida law that says what he just read here. I'm going to hear it again. Not in Florida law at all, as we just saw. I wonder where he might have gotten that sentence. Well, it turns out, amazingly enough, that it's not in law. He got that sentence. Apparently, this is the only place I've been able to find it, from an academic paper, Deadly Combinations, How Self-Defense Laws Pairing Immunity with a Presumption of Fear Allow Criminals to Get Away with Murder. Does this sound like an unbiased piece of academic literature? By Elizabeth Magali. So we looked through this paper, and I looked through it for that specific language, and I find it. An absolute and rebuttable presumption that an individual, let me expand this so we can see it more clearly. An absolute and irrebuttable presumption that an individual who kills or harms another within that individual's castle has acted in self-defense and cannot be prosecuted. Well, now we're adding the word castle. Did he say castle? I honestly don't remember. Let's listen. No castle. He can't even read correctly, this guy. So what about this phrase? Does this mean it's in Florida law? No, it's not in Florida law because she references 776-013 and 776-032. What are those? What are those? Let's take a look at those. 776-013 is Florida's Defense of Highly Defensible Property statute. And it creates a legal presumption if you're dealing with some forcibly and unlawfully entering your home, a legal presumption that you had a reasonable fear of imminent deadly force harm from that person. But those are conditions that have to be met. It's a rebuttable presumption, as we already talked about. It doesn't say you cannot be prosecuted. And the other statute he mentions is 776-032, which is Florida's self-defense immunity statute. And it says, well, like I explained, self-defense immunity, if you meet the conditions of self-defense. I boomed the audio on that. It's okay. We already heard a sentence several times. If you meet the conditions of self-defense, you're granted immunity from prosecution. There is no presumption here. There's no legal presumption in the self-defense immunity law. So this sentence, although numerous problems exist with stand your ground laws, this article focuses on those grievous harms resulting from the combination of a presumption of reasonable fear, that's true in highly defensive property laws, and immunity. Read in pari materia. What's in pari materia mean? That's just a fancy Latin way of saying, reading the two statutes together, Florida statutes create an absolute and irrebuttable presumption that an individual who kills or harms another within that individual's castle has acted in self-defense and cannot be prosecuted. It doesn't do anything of the sort. Self-defense immunity is not presumed. You have to go to court and have a hearing and fight the state to qualify for self-defense immunity. And a judge has to agree that you qualify. There's no absolute privilege to self-defense immunity. And the privilege within your home has to meet all those conditions of someone unlawfully and forcibly entering your home and fail to trigger any of the exclusions, and is still rebuttable. None of this is absolute. This is just a partisan misrepresentation of Florida law that this dope isn't even quoting accurately, excluding the part about the castle. So much for him. Let's continue. Now that he's blatantly misrepresented Florida law on stand your ground and defense of highly defensible property.
This began the spread of a heightened stand your ground law in many states.
None of this, none of what he just said, none of what we just read in this paper has anything to do with stand your ground. It's a combination of defense of highly defensible property, castle doctrine, mistakenly called, and self-defense immunity. Remember the distinct legal doctrines. What the paper is combining is some combination of self-defense immunity and defense of highly defensible property. These two bottom items, neither of them has anything to do with stand your ground. None. Genius.
That change the legal presumption. So if you make
the legal presumption only applies in your home if you're dealing with a forcible, unlawful intruder. Stand your ground is irrelevant inside your home. Stand your ground only has applications outside of your home.
make a stand your ground claim, all you need to do is say, I felt that my life was in danger. Or
he's saying that's all that's required for self-defense is that you had a subjective fear of harm. That is a lie. That is a lie. Let's go back to Florida law, shall we? Shall we actually look at the law? How about that for an idea? How about that? Florida statute 776012, use or threatened use of force in defense of a person. You're justified. Let's just look at the deadly force one. That's the more important one. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death, blah, 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 blah. It's a subjective belief is not enough, folks. A subjective belief is not enough. So he's, again, blatantly misstating the law. And if we look at the defense of highly defensible property statute, it's not saying that a fear of harm is not required. It's saying that fear is presumed. Again, it's a rebuttable presumption, but it's still a required element of a self-defense claim. An irrational fear of harm is not enough. Back to the genius. Guess under what circumstances the burden is on the state to overcome your claim of self-defense. Is it only stand your ground states? No, folks. No. In every state in the country, the burden is on the prosecution to disprove self-defense beyond a reasonable doubt. Stand your ground has nothing to do with that. These 11 duty to retreat states, guess who has the burden on self-defense here? Yeah, you're right. Even in the duty to retreat states, the state has the burden to disprove self-defense beyond a reasonable doubt. Stand your ground does not impose that burden. That burden is inherent to the very nature of self-defense. Another reason, these are distinct legal concepts. Let's hear some more from the genius.
And this shift in the legal standard
was not a shift in the legal standard. Not a shift in the legal standard. The legal standard was already that the burden was on the state to disprove self-defense beyond a reasonable doubt. Stand your ground did not impose that burden. It was already in place. There was no shift.
Has really opened the door wide for people to make stand your ground type claims, and in many instances, not all obviously, to avoid any kind of prosecution. And that widening of stand.
Now he's using the phrase stand your ground to mean self-defense immunity. Two distinct legal doctrines. All stand your ground means is if you're out in public and you have an otherwise lawful case of self-defense, you're not required to retreat. Self-defense immunity says if you qualify for self-defense, however it's defined, you can be granted immunity from prosecution. That's a good law. If what you did was self-defense, why should you be subject to a trial? And that determination of self-defense is made in court, in a hearing, with the prosecution arguing against you in front of a judge. And the judge makes the call whether or not you qualify for immunity. It's not some magic button you press and suddenly you can't be prosecuted. So now he's saying the word stand your ground, but he's talking about self-defense immunity, that you can't be subject to prosecution. Yeah, that's not just inflammatory. Can you believe we're 35 minutes into the show and only 2 minutes and 49 seconds? Sorry, folks. I'll rewind a little bit.
And that widening of stand your ground on steroids, or some even call it a license to kill, or
license to kill, inflammatory, purely inflammatory rhetoric.
Shoot first laws. That is what is really
shoot first laws. a shoot first law. Guess who shot first, folks? Han Solo shot first, and that was lawful. You're allowed to shoot first if you meet the conditions of self-defense. There's nothing wrong with shooting first.
Come to the country's attention in recent years.
Where does this idea come from? I mean, is it rooted anywhere in the sort of the history of
what idea? He's conflated half a dozen ideas
of gun laws in America?
Well, stand your ground laws take an older idea, something called the Castle Doctrine, an old principle that people may have heard of. The Castle Doctrine goes back to the Middle Ages. A person's home is one's castle. That is to say, you have a right to retreat into your home and feel safe there. And if somebody intrudes within your home, you're entitled to defend yourself and not leave your home.
Holy crap, you got something right. How about that?
That idea goes back to the Middle Ages. In Britain, it came to the United States. But in the 19th century, another idea evolved, and that was the stand your ground idea. That is to say, if you're in a public place, the principle of the Castle Doctrine in your home could apply to you in the public realm. That is to say, instead of safe retreat, which is the legal standard even today in many states.
Where is it the legal standard? Where's the legal standard that there's a duty to retreat? 11 states. About 1/5 of the nation. Many states, my ass. Stand your ground is the law in many states, 39 out of 50.
You could meet force with force.
The idea behind these, the sponsors of these bills.
Stand your ground is not what justifies you meeting force with force. Self-defense is what justifies you meeting force with force. This is what defines when you can meet force with force and how much. All stand your ground does is remove the element of avoidance. That's it.
And backers said it was intended to curb crime. Is there any way of telling the result of these laws?
Oh, so this is another piece of propaganda, standing headline nonsense that these people do. They conflate the words homicide with murder. Watch this. He was asked about crime, and he's going to talk about homicide.
There is zero evidence that stand your ground laws of recent years have deterred crime or improved public safety. And a host of studies, numerous studies, have demonstrated that what we see when these stand your ground laws are enacted is an increase in homicide and gun homicide. Several studies have found an increase between 8 and 11% in homicides in states after they adopt these laws. The state of Missouri, which has come under focus just in recent days, and not adopted.
All right, so let's talk about homicide. Homicide is not murder, folks. Murder is an unlawful killing. One person kills another unlawfully. Homicide is merely one person killing another. It's not necessarily unlawful. When that maniac with the machete kicks in your front door and comes into your home to kill you and your wife and your children, and you shoot him dead, that was a homicide. It was not a murder. When a woman is targeted by a rapist and she kills the rapist in self-defense, that was a homicide. It wasn't a murder. When you're the victim of a carjacking, an armed carjacking, and you defend you and your wife and children in the car by killing the carjacker, that's a homicide. It's not a murder. So in all those cases, homicides went up by 3. He wants you to believe that's a bad thing. He wants you to believe you should have died. You, your wife, your children, in your home, in your car, should have been killed by that criminal aggressor. It's contemptible. Whether or not a homicide is a good or bad thing depends on who is doing the dying. It's not inherently a bad thing.
Adopted a stand your ground law in 2016 and also eliminated pistol permitting for pistol carrying. And indeed, Missouri witnessed an even larger increase in its homicide rate thereafter. In addition,
homicide is not necessarily a bad thing.
There's a race problem, which is,
Of course, it's unfortunate when anybody dies. But if the alternative were an innocent person were to die, the lesser of those evils is that the criminal aggressor pays that price.
is that these laws tend to be administered in an inappropriate way between the races. So if a white person,
Now he's talking complete garbage. There's absolutely no data to support this. It's just a propaganda talking point of those who just hate self-defense and therefore hate stand your ground.
kills a black person, let's say, makes a stand your ground claim,
The people who benefit most from stand your ground are the people who are most likely to be compelled to engage in self-defense. You think that's a well-off lawyer living in an HOA like me? Or are you thinking that might be a poor black kid in a crime-ridden neighborhood? The people who benefit most from stand your ground are poor people in high crime neighborhoods who are most likely to be compelled to lawfully defend themselves.
that claim is much more likely to be accepted than the reverse. And there are studies that support that conclusion. So it is deeply problematic. And indeed, law enforcement and prosecutors have generally opposed the enactment of these laws.
Well, of course, cops and prosecutors don't like to give up authority. When they take past stand your ground, they're taking avoidance off the table as a target of attack on your claim of self-defense. Of course, prosecutors don't want to give that up. They want as many targets of attack as possible. Don't worry, they'll say, we'll use our judgment to decide if you shouldn't be prosecuted. You can trust us. So leave us with that fifth target of attack. Leave us with avoidance. Don't pass stand your ground. Even though all stand your ground means is that you still have to have been the innocent victim of unlawful, imminent, deadly force attack reasonably perceived. And they still want to put you in a cage for the rest of your life if they can convince a jury that you could have run away.
You mentioned permitless concealed carry. These two sort of trends, we've now had the 26th state, Florida, have a law that you don't need a permit for concealed carry. Combined with these stand your ground laws, what is the effect, or what do you think could be the effect?
Well, it means more civilians owning guns.
More criminals or more law-abiding? Because the criminals weren't getting a permit in the first place. So doing away with the need for a permit affects criminals not at all. They already weren't getting a permit. Doing away with the permit enables poor people, disproportionately black people, to be able to have a gun on their person to protect themselves and their family without having to spend hundreds of dollars going through a permitting process. Who's racist? You sound racist, Professor.
And more civilians carrying guns with them around in society in now 26 states. And civilians lack the training, skill, judgment, and the likelihood of mistakes, or the likelihood of road rage, or the likelihood of spontaneous anger resulting in the deployment and firing of.
He's describing himself. And he's projecting that onto the population generally. He believes he would be unsafe. He believes he would be subject to road rage, poor decision-making. He's describing himself. Listen.
Or the likelihood of road rage, or the likelihood of spontaneous anger resulting in the deployment and firing of a gun by a person carrying it are much greater, and the murder statistics bear that out.
Robert Spitzer, thank you very much.
You're most welcome.
Thanks for nothing, you dolt. Ridiculous. All right. That was the first expert. There's more, folks. I got two more of these. Two more of these. So now we have Fox News. Fox News. And they have this guy on. His name is Duncan Levin. Former federal prosecutor, it says here. Well, that sounds impressive, right? Former federal prosecutor. I've never been a federal prosecutor. Pretty cool. And he's got this, I like the nice, like, random scattering of textbooks behind him. That's very legal scholarship there. So what's this guy's expertise in use of force law? Well, first of all, when you see federal prosecutor, that should set off alarm bells, because virtually no self-defense cases are argued in the federal courts. 99.999% of them of self-defense cases are argued in state court, not federal court. It would have to be some weird aberration, an attack on a federal law enforcement officer, something along those lines. Virtually never happens. Very, very little. But then even that would be handled by a federal prosecutor who does criminal prosecutions. Sorry, violent crime prosecutions. Does this guy do violent crime prosecutions? I wondered. So I took a look. Who is this guy? Duncan Levin, a storied career as a federal prosecutor. His bio says, Mr. Levin served as a federal prosecutor with the U.S. Department of Justice, specializing in money laundering and asset forfeiture. There's nothing in his professional background that has anything to do with use of force law. Nothing. This is the Fox News expert on stand your ground and use of force law doctrines. Impressive. I think not. But maybe I'm wrong. Maybe I'm being misled by his background, his lack of background in the subject matter in which he's purporting to be and is presented as an expert. Let's see what he has to say. By the way, someone should teach him how to tie a knot in his tie. That's like a 12-year-old going to communion.
So much for taking the time here to join us.
Hey, Josh, how are you? Thanks for having me on. Appreciate it.
Of course. So first off here, kind of break down for me what the stand your ground law even is.
Yeah, let's hear it. What is stand your ground? What's it mean?
Sure. Well, this all comes from the common law, and there's something called the castle doctrine, which has been around for hundreds of years. And that basically just says that your home is your castle and you have the right to use reasonable force, including deadly force.
Is that what the castle doctrine means? That you have the right to use force? No, folks. Self-defense says that you have the right to use force. Self-defense says you have the right to. How do we know? Do you have the right to use force outside your home? If the 5 elements of self-defense are met? Yes. You have the right to use force anywhere to defend yourself if you meet the conditions of self-defense. Using force in self-defense is not a condition of being in your castle. So the castle doctrine has nothing to do with that.
If somebody is trying to intrude into your home. And over the years, this has been codified.
I think he doesn't know he did this, but he said if someone is trying to break into your home, so they don't have to have broken in, they have to be reasonably perceived as trying to break in, which would, of course, apply to this Missouri case, right? With the black teenager at the wrong house, 84-year-old homeowner shot him. For that to be lawful, the homeowner needs to have perceived that this person on the other side of the door was trying to get in.
By state legislatures and expanded upon, and every state has some little variation of it. Some have more robust laws like.
So he just said every state has some variation of castle doctrine. That's true. Every state does.
Kansas, which has something called stand your ground. And then some others have sort of watered down things, which are kind of nicknamed make my day laws. But
okay, now he's just making stuff up. So you have castle doctrine, relieves you of a duty to retreat inside your home. You have stand your ground, does the same thing outside your home, relieves you of an otherwise existing duty to retreat. What is this make my day law? What is that about? What is that supposed to be? Well, Make My Day, of course, was made famous by Colorado. Colorado passed a statute that became commonly referred to as the Make My Day statute. What is that statute? You know what it is, folks? All it is a defense of highly defensible property statute. Remember this? The 5 doctrines: self-defense, castle doctrine, stand your ground, defense of highly defensible property, where you have these special provisions for the use of deadly force in the context of your home that you wouldn't have outside your home. Most states create a legal presumption that you had a reasonable fear of imminent deadly force harm from that person breaking into your house. Colorado does it a little differently, but it's still, the supposed Make My Day law is still just a defense of highly defensible property statute. And this is it here. It's statute 18-1-704.5. Notwithstanding the provisions of section 18-1-704, which is just a self-defense statute, an occupant of a dwelling is highly defensible property, is justified in using any degree of physical force, including deadly physical force, against another when that other person has made an unlawful entry into the dwelling. This is just a defense of highly defensible property statute. It's not some weakened version of stand your ground, which is how he presents it. Let's hear him again.
And some others have sort of watered down things, which are kind of nicknamed make my day laws. But
Completely
basically,
different
at the
doctrines.
core of it is some variation of law that codifies this notion that you are allowed to defend your home against an attacker, that you are allowed to not only not retreat in certain instances, but you're allowed to use deadly force in response to an intruder. So all of the state laws are a little bit different, but Kansas is in particular, because that's where we're, one of the states we're talking about is actual, and Missouri as well, and some other states have stand your ground laws.
So based on this legal principle here and just the definition of that, is that a likely defense that would work in either of these cases that we are talking about?
Stand your ground is not a defense. Stand your ground is not a legal defense. The legal defense you would raise if you're charged with a crime for using force against another person, the legal defense is self-defense. It's this. All stand your ground does is say, but we're going to remove the element of avoidance. The legal defense is still self-defense. There's no such thing as a stand your ground defense. Anyone who uses that phrasing simply doesn't know what they're talking about.
Well, New York doesn't have a stand your ground law, although it does.
That's true. That's true, right? Look at the 11 duty to retreat states. One of them is New York. New York does not have stand your ground. New York is a duty to retreat state. Got one right. Amazing. He got one right. All right, but let's see how long it takes him to get one wrong.
Does obviously have some common law notion that you can defend yourself, but
New York has some common law notion that you can defend yourself. What's the common law, folks? Common law is ancient law that was created by courts before we had statutes, before the law was codified into statutes. So in Old England, we had Blackstone's common law. Blackstone was one of the first legal scholars and judges to write down all the common law in a book. But these were all based on various court decisions, the norms of legal practice, hundreds of years ago. In modern America, we still have court-made law. We call it case law now, and we have statutory law. Those are the two forms of sources of law in America, and of course the Constitution. But we have case law and we have statutory law. Here he's saying that New York doesn't have stand your ground, but it has some common law privilege to use force in defense of yourself. Well, actually, Mr. Former Federal Prosecutor, New York actually has statutory law. It's not common law. It's a statute. Section 3515, justification, use of physical force in defense of a person. Common law, my ass. All right, let's continue. The Kansas City case is the young black gentleman who came to the door and the 84-year-old homeowner shot him, presumably because the homeowner believed the gentleman outside was trying to get into his home. If the use of force event is your home, folks, stand your ground is irrelevant. It's irrelevant. All stand your ground does is remove an otherwise existing duty to retreat if you're in public. If the use of force event is in the context of your home, you're still relieved of an otherwise existing duty to retreat, but that's castle doctrine. Stand your ground has nothing to do with it. Nothing to do with defense of your home scenario.
Why, which is that I don't think there's really any evidence here that he was being attacked, that this 80.
So the 84-year-old, there's no evidence he was being attacked. The whole point of the Missouri law is that if you're defending yourself in the context of your home, you don't have to show that you were in fear of being attacked. You merely have to show that such force, deadly force, is used against a person who unlawfully enters or attempts to unlawfully enter a dwelling. The reasonable perception of someone attempting to unlawfully enter the dwelling is an alternative justification for the use of deadly force. You no longer need to show that you had a reasonable perception that you personally were being attacked. That's the whole point of Missouri's defense of highly defensible property statute. Again, this dummy just has no idea what he's talking about. So the second shot of Ralph Yarl on the ground, as I've noted in my own analysis, that is legally problematic if it happened. The homeowner doesn't say, I shot him while he was on the ground. So that is a fact in dispute, and he's presenting it as a fact that's undisputed. I wish this was automatic. Sorry, I'll rewind it a bit. Here we go.
I don't think there's really any evidence here that he was being attacked, that this 85-year-old man, maybe he was scared, but there's no evidence that he was actually being attacked.
Not required that he was actually being attacked under Missouri law to be justified in using deadly force if he had a reasonable perception that someone was attempting to unlawfully enter his home.
Shot the victim here through a locked door, through a glass pane and a locked door, and then shot him a second time while he was lying on the ground. And so
that's the second claim I'm talking about. That's a fact in dispute. The homeowner doesn't say, I shot Ralph Yarl while he was laying on the ground. Ralph Yarl claims that, but that's a fact in dispute. And this guy's presenting it as if it were a fact not in dispute. The girl on the right might have been, that might have been the girl from New York who went up the wrong driveway in her car, and the homeowner came out of his house and shot the car and killed her. That looks like straight up murder to me.
Particularly for that second shot, there's really no credible case that he thought he was being under attack. And so I think it was,
again, the correct question is not for the second shot, did he believe he was under attack? The question would be, even if you believe the second shot was Ralph Yarl on the ground, the proper question would be, with the second shot, if Ralph Yarl were on the ground, could he have a reasonable perception that Yarl was still attempting to unlawfully enter his home?
You know, to say it was an overreaction puts it mildly, given the seriousness of it. But I don't think they're going to be able to actually make this out at the end of the day.
And do you think this is going to lead to any sort of change, whether you're talking about at the local level, state level, federal level? We do know that this has come up a lot, especially over the last several days and weeks here. Is there the possibility this leads to any kind of change?
It's hard to tell. I mean, a lot of these laws have been around for hundreds of years. You know, this notion of stand your ground in Florida, though, is relatively new. It was passed in 2000.
The notion of stand your ground in Florida.
5. So some of the laws are new, but this notion of stand your ground in Florida, though, is relatively new. It was passed in 2005.
So the notion of stand your ground, relatively new, passed in Florida in 2005. Folks, do I have something to share with you? All right, let me take a look to pull it up specifically. In 2005, self-defense, stand your ground, relatively new, relatively new. Well, I'd like to share a case with you. Let me make that bigger. Remember, what is stand your ground? Stand your ground says that if you have an otherwise lawful claim of self-defense out in public, you don't have a legal duty to retreat. Relatively new? Is this relatively new? Remember, I showed you that map, right? The map, the stupid map of their, where is it? Oh, here it is. Oh, what happened to the map? Oh, I didn't have it recorded. That was in the from the first video. That was from, here, I can get it. That was from the PBS show. This map. Remember this map? The yellow ones are supposed to be the stand your ground states, and the non-yellow ones, presumably not stand your ground states. And I pointed out that Washington, Oregon, California are all stand your ground states, but not colored yellow in this map. So he says stand your ground, relatively new concept. Florida, 2005. Let's take a look. Let's take a look at California. Why do I say California is a stand your ground state? By the way, California does not have a stand your ground statute. That's for sure. But statutes are not the only source of law. Statutes and court decisions, case law, is as legitimate a source of law as are statutes. And if we look at California, what do we find? Oh, look, here's a California Supreme Court decision from 1897. I think that's a little earlier than 2005. Would you agree? 1897? 1897, People v. Lewis. And by the way, for any articles or court decisions I mentioned here, if you are a law of self-defense member, when we upload today's show to the member blog, I'll put links to all this for the members. We're not doing that for YouTube and Rumble anymore, folks. It's too much work. You need to be a law of self-defense member to be able to access the links to all the sources for this stuff. But here's People v. Lewis, Supreme Court of California, 1897. And what do they say about the duty to retreat in California in 1897? Our law nowhere imposes the duty of retreat upon one without fault himself is exposed to a sudden felonious attack. That means, of course, you don't have a duty to retreat in an otherwise lawful claim of self-defense. Continuing, this state, California, has upheld a defendant's right to stand his ground, and meet by force a sudden and violent attack. Stand your ground. California, 1897. New with Florida in 2005, my ass. And by the way, if you look at California's jury instructions today, this is the modern California jury instruction for self-defense, CalCrim 505. Not only are you allowed to stand your ground, but note here, a defendant is not required to retreat. The jury in California is instructed. He or she is entitled to stand his or her ground and defend himself or herself, and if reasonably necessary, to pursue an assailant until the danger of death has passed. That is turbocharged stand your ground in California. Study up, Duncan Levin. Let's continue with him.
Some of the laws are new, but the underlying doctrine's been around for a long time, this Castle Doctrine. And so I don't know whether it's the laws are going to change, but I do think the application of it is going to get more and more under scrutiny.
So the law won't change. The black letter law won't change, he's saying, but the application will be different. I wonder what he means by that.
Because as we see these cases, I think jurors are understanding now that they have to look beyond somebody just saying, oh, I was feeling scared.
All right, first of all, the law doesn't say a mere subjective fear of harm is enough. That's not what the law says. That's not what the person's allowed to claim and qualify for self-defense. I was merely feeling scared. They have to, of course, have genuine good faith belief in the need for self-defense. But the law requires, under reasonableness, that belief was also objectively reasonable. This guy presenting that you can kill someone and justify that with purely a subjective fear of harm is bullshit. It's utter legal bullshit. Plus, he's saying juries, the law isn't going to change, but juries will have to apply it differently. Is he suggesting that juries should come to verdicts other than how they are instructed under the law? Does that sound appropriate? Does that sound like justice to anybody? Or does that sound like conviction by the whims of a jury?
Because a lot of it is pretextual, and they have to look at that and judge whether this person's actually telling the truth or not. That just comes down to evidence. So I think on a case-by-case basis, we'll see jurors are going to become more skeptical of stand your ground claims.
And do you think overall people don't?
There's no such thing as a stand your ground claim. What does stand your ground do? Stand your ground takes avoidance off the table as a required element of a claim of self-defense in an otherwise lawful case of self-defense. You don't get up in court and say, I claim stand your ground. That's not your legal defense. Your legal defense is self-defense, but you're relieved of one of the otherwise required elements of self-defense. You don't claim stand your ground. By the way, if stand your ground is law, you don't have to claim it. You're simply not required to retreat.
Don't fully understand what stand your ground
Oh,
laws
this part
are.
is
They
really
think they,
rich, really
and
rich.
do you think overall
Look at
Let's
that
listen
and
to the talking head over here, Chad on the left. What's he got to say?
judge whether this person's actually telling the truth or not. That just comes down to evidence. So I think on a case-by-case basis, we'll see jurors are going to become
What are your
more
deep
skeptical
thoughts,
of
Chad?
stand your ground claims.
and do you think overall people don't fully understand what stand your ground laws are?
Why do you think that people might not properly understand what stand your ground laws are, Chad? Why do you think that? You think it's because you and Duncan are communicating a misrepresentation of what stand your ground is to maybe, well, it's Fox News, tens of thousands of viewers? The public's confused about stand your ground. Well, I damn well wonder why, Chad.
They think they understand it, but don't necessarily fully comprehend it.
Yeah, I think that's part of the problem is people think that it's a license to shoot somebody who comes up their driveway.
Why do they think that? Why?
And I think a lot of people misunderstand that. It is
Why do they misunderstand it, Duncan?
stand your ground laws is not a license to start shooting people who knock on your door. That is not what it is. It's never been what it is.
That's true.
It refers to the situation where there's an intruder in your home. And
No, stand your ground has nothing to do with an intruder in your home. Castle doctrine has to do with an intruder in your home. God, I swear. These are distinct legal doctrines. Stand your ground has nothing to do with your home. It only applies outside the context of your home. If you're in the context of your home, it's castle doctrine that's relieving you of an otherwise existing duty to retreat, not stand your ground. Defense of highly defensible property is in the context of your home, not stand your ground.
and saying that you have the right to use reasonable force, including deadly force, to protect yourself. But this notion of protecting yourself against an intruder in your home is very different than shooting somebody who's outside your door or who's driving in your driveway. That does not give you license to use deadly force. And I think a lot of people don't understand that and
I wonder why a lot of people don't understand the distinctions, Duncan.
say that they're standing their ground when that's really not what the law is talking about at all.
Any idea why we've seen so many of these types of shootings recently and why so many people are saying, you know, this is related?
All these shooting recently. Wow. What's going on with all these shootings recently? I wonder. Let's see. I had a little slide on this too. Let's consider all these shootings happening recently. All these news reports are talking about the same four ones. The same four. These four. 4 out of a population of 334 million people plus. So what percentage of the population is involved in these events? 0.0000001%, folks. That means 99.999999% of the population not involved in this. Is this a plague of stand your ground on the face of America? I think not, Chad. By the way, I don't know if his name is Chad. He just looks like a Chad.
Related to the stand your ground law. Is there any reasoning behind it? And also, kind of another question here, do you think that in the near future, now that people do kind of understand the stand your
Thanks, Chad. Thanks to you, people kind of understand stand your ground now. Well, if they watched this version of your show, they might.
Ground law just a little bit further, that maybe it will be used less as a defense in cases like this.
Stand your ground is not a defense. The defense is self-defense. That's the legal defense. It's just a self-defense without the requirement of avoidance. That's all stand your ground does.
I think we're seeing it because we have too many guns in the street and everybody.
Again, it's just another, this is all, here comes the gun control propaganda. The guns are self-animating and killing people.
Has a gun. And so with the proliferation of guns, we're going to see more and more senseless shootings, and we're going to see people who don't understand the law.
You know, the proliferation of guns, America has more guns than people, and they're everywhere. And yet the violent crime only seems to happen in a dozen urban centers. Isn't that weird? Is it the guns? Duncan, might there be, I don't know, a demographic explanation where 5% of the population is committing 50% of the violent crime? Might that be an issue? I've owned guns all my life, and none of them have committed violent crimes.
But have a gun, take the law into their own hands, and you're going to see more cases like this. It's not just a proliferation of shootings.
Self-defense, the legal defense of self-defense is literally a legal privilege for you to take the law in your own hands. It's self-help. You're not required to ask someone's permission beforehand. You're not required to get a certificate from the government. Can I use force on that person attacking me? You're literally taking the law into your own hands. And then you're judged for that conduct afterwards. But that's literally what self-defense is.
Involving police officers, it's shootings involving people who are not police officers. And so I think we're seeing a rise in gun violence across the country.
Gun violence, because guns self-animate and commit acts of violence. I never knew that.
This is another symptom of the problem. And, people are going to try to excuse their actions by pointing to the law. And that's why.
Oh, my God. Oh, my God. People are going to attempt to excuse their actions by pointing to the law. You know what that's called, folks? That's called due process of law. Of course, you can excuse your actions under the law. You can justify your actions under the law. Because a justification, a legal justification or a legal excuse means it's not a violation of the law. It's not a crime. This is a former federal prosecutor who objects to people excusing their conduct under the law.
I think they need to be held to account in every instance that stand your ground is a very narrow category of defense, and it doesn't really apply to many situations where people are misusing handguns.
All right.
What about where people are misusing fists or bats or cars?
Thank you so much, Duncan Levin. We appreciate you taking the time to join us, as always. Anything else you want to add about all of this before I let you go?
Yeah, I can't wait to hear what Duncan has to add at the end. What do you got to say, Duncan?
I appreciate it. Thanks for having me on.
Not much. All right. So that was Duncan. It's just disparaging a perfectly good donut shop. All right, last one, folks. Last one. This one will be shorter, both because it's half the length, and I do want to preface. So when I put this next lawyer up, it strikes me as he's attempting to share genuinely solid information. Okay, it looks to me like he's actually just reading, and this is in North Carolina. This is a local North Carolina news station. It looks to me like he's just reading the North Carolina law. It's hard to go wrong. I mean, there's some risk that, if you don't know the case law, you could misinterpret the statute, but at least he's actually reading the statute, it looks like to me. That said, this guy also appears to have absolutely zero experience or training in use of force law at all. At least he's a lawyer. And again, credit to him. He appears to be trying to do the right thing by reading the actual law, not just making stuff up. Pulling stuff out of his butt. And what he says is because he's reading the law, he's getting it right. I mean, it's a good way to have a high degree of confidence that you're getting the law right is to be reading the actual law. But nevertheless, the communication of the law to the audience is badly distorted, not because of the lawyer. I don't want, those first two guys were just poopy heads. I think this lawyer is well-intentioned, but the way they chop up his little video clips and then misinterpret what he said miscommunicates the law. But that's not on the lawyer. That's on the media person here. So I want to make that clear. By the way, we know already this is propaganda because they're not talking use of force law. That's not the title here. The title is gun violence, an epidemic. Is it an epidemic, or is it just, first of all, what's gun violence? Guns don't self-animate and commit acts of violence. Second of all, is it like smallpox? It's spread homogenously across the population, or is gun violence largely concentrated within 12 urban centers in America? I don't think it's an epidemic. Certainly not a gun violence epidemic. So we already, oh, by the way, look, look, they have a pistol here. Look at those pistol rounds. That's pretty amazing. I don't think even the Desert Eagle fires that, does it? I think you need like a Thompson Contender. And those look like pretty damn, it's hard to tell. Who knows if they messed up the scale. But I would discourage you folks from attempting to fire those rounds in that firearm. That will not go well. All right, so this one's only 3.5 minutes long. Let's listen to what they have to say. And again, most of the misinformation here is not from this lawyer. So it's from the media reporters.
Chapter in America's gun violence epidemic, a wrong address, a wrong driveway, and a wrong car. The string of tragedies unconnected except by the fact.
Does just that narrative, that script she just read, you think that comes right from the Giffords Foundation for gun control? It sure sounds like it.
That in each case, someone had a gun and the will to use it. High school cheerleader.
What's wrong with having a gun and the will to use it? I have a gun. I've got a gun on me now, right now. I've got the will to use it. No problem so far.
Peyton, Washington, the latest victim after a stranger opened fire on her and 3 friends in the parking lot of a grocery store outside Austin. The girls mistakenly approached the wrong vehicle after a late night cheerleading practice.
Oh, look, this is the shooter, I guess. Folks, if you unlawfully enter someone's vehicle, occupied vehicle, it's no different than unlawfully entering their home. It's the same defensive, highly defensible property scenario. And obviously do I need to say it? This guy does not appear to me to be the typical white supremacist.
Police arresting Pedro Rodriguez Jr.
Pedro.
In upstate New York, Kevin Moynihan pleading not guilty to.
So this is the guy who shot at the car that was just coming up his driveway. They were apparently a car of people lost, and he shot at them and killed a young woman. This looks like straight up murder to me.
Murder and in jail without bail. He's accused of shooting and killing 20-year-old Kaylin Gillis. She was in a car that accidentally pulled into his driveway looking for a friend's home. Those coming after a Kansas City teen was shot after going to the wrong home.
So they have 3 cases they're citing here as an epidemic of these stand your ground problems.
Pick up his younger brothers. The 84-year-old suspect pleading not guilty Wednesday to 2 charges. He was released on a $200,000 bond. Missouri is one of dozens of states that have stand your ground laws in place. But what about North Carolina? Wake Up Charlotte's Megan Bragg looks into our self-defense laws in today's Verify Fact Check.
What's self-defense
law? Megan Bragg looks into our. What about North Carolina? Wake Up Charlotte's Megan Bragg.
Megan Bragg. Let's see what Megan Bragg has to tell us about North Carolina self-defense law. You go, Megan.
Looks into our self-defense laws in today's Verify Fact Check.
North Carolina is one of at least 28 states with stand your ground laws in.
All right, North Carolina is one of 28 states with stand your ground laws. Oh my Lord. Oh my Lord. Why? Why do they do this to me? These are the states that don't have stand your ground laws. 11. 39 states have stand your ground laws, folks. 39.
Place.
Fact check.
North Carolina is one of at least 28 states with stand your ground laws in place. For more on what this law means, we went to attorney Gary Mauney, partner at Mauney LLC.
Okay, so Gary Mauney, and I don't mean to give this guy too much heat because again, he's reading the statutory language. That's the source of law. He's doing it right. But when you do look at him, there's no use of force law expertise here. Here's his law firm. I'm sure it's a fine law firm. I have no criticism of it. But this is what they cover. Business tort litigation, that's lawsuits, financial fraud, personal injury, tax shelters, professional malpractice, forensic investigations. This would be financial forensics, fraud, whistleblower actions, class actions, appeals. There's no criminal law here, much less use of force law. There's nothing here. And if you look at his bio, and again, I'm sure he's a perfectly nice guy. I focus my time and energy. Whoops. Here's his bio from his website. I focus my time and energy on litigation that involves business and financial disputes, securities and accounting fraud, and partnership or merger disputes, accounting and financing. This is just not a criminal defense lawyer. And there's nothing wrong with that, of course, but he's being presented as an expert on use of force law. So here we go.
And the law itself.
You're allowed to.
So one thing I notice about this guy's statements, they really clip them very tight. And for every one of his statements, they often present them in a context where if what he's saying is in the context they're presenting, it would be incorrect. But keep in mind, he's making these statements without the context they're superimposing here. And if you take his statements and you presume he meant them in the correct context, they are correct legal statements. So the errors here, I'm going to defer to the attorney getting it right. Again, he's reading statutes. The error here is the news reporting, not the attorney.
You're allowed to use deadly force, and I'll read it. If there's a reasonable fear of imminent death or serious bodily harm.
Under North Carolina's stand your ground law, there are three.
All right, that is not North Carolina's stand your ground law, folks. That is simply North Carolina self-defense law and relief from criminal or civil liability. So it's a combination self-defense law and self-defense immunity law. It's not a stand your ground law. All stand your ground would say is within the context of self-defense, we're taking avoidance off the table. That's all. So in fact, you see it here. Look at this first paragraph. A person is justified in using force except deadly force. So the first paragraph here is the non-deadly force statute. To the extent you need to defend yourself against imminent unlawful use of force, those are the 5 elements. And then it adds so all that has to be true. And then it removes the element of avoidance. It says, however, this is the deadly force. However, a person is justified in the use of deadly force and does not have a duty to retreat in any place he or she has a right to be if they're facing death or great bodily harm. So all the elements of self-defense are still there. They're just saying you don't have a duty to retreat.
3 places where deadly force can be used if you are scared for your life: your home, your workplace, or your car.
All right,
this is where deadly force. North Carolina stand your ground.
She's going to say there's 3 places you can use deadly force to save your life. 3 places. Listen carefully.
Law. There are 3 places where deadly force can be used if you are scared for your life: your home, your workplace, or your car.
Could that possibly be true? That in North Carolina, the only places you're allowed to use deadly force if you're in fear for your life is your home, your place of business, or your car? When we look at the actual, actual North Carolina statute, does it say that? Or does it say a person is justified in the use of deadly force?
Ground law. There are 3.
And does not have a duty to retreat in any place he or she has a lawful right to be if they reasonably believe that such force is necessary to prevent imminent death or great bodily harm to himself, herself, or another.
3 places where deadly force can be used if you are scared for your life: your home, your workplace, or your car.
Of course, you can defend yourself in your home, your workplace, and your car, and anywhere else where your use of deadly defensive force would be justified by the statute. This is only the highly defensible property context, folks.
So someone comes into your home It's presumed under the law of North Carolina that the person coming into your home without permission is there to do you harm.
Right. That's the legal presumption I've talked about in the context of highly defensible property, where it's legally presumed that you have a reasonable fear of unlawful, imminent, deadly force upon you.
And so you are allowed to use deadly force.
But before you shoot,
And of course, they use a fake gun here, folks. Is it hard to tell that's a fake gun? I guess it could be a, oh my gosh, what the heck is that? The cheapo gun that you can yeet across a room with the giant slide. It could be one of those. I'm blanking on it. Really cheap guns, pistols. Someone will put it in the comments. But obviously, this is just a fake. This is the plastic gun. High point. That's what I was thinking of. Yeah.
Mauney says you need to have reasonable fear of death.
It has
Thanks,
to
Shane.
appear to a reasonable person.
Shoot,
Right.
Mauney says you
have to have a reasonable fear of death, not just a subjective fear of death, not just I'm scared so I can shoot. It has to be objectively reasonable, not an irrational fear.
need to have reasonable fear of death.
It has to appear to a reasonable person that someone is trying to come into your home unlawfully.
Again, he gets it right. Is it required that they actually enter your home? No. To trigger this legal presumption under highly defensible property, it has to reasonably perceive that they're trying to unlawfully enter your home.
Breaking and entering, breaking your door down, trying to get into your car door.
Mauney says
So if someone's trying to get into your car door, what are they doing? They're working the handle of the car door, right? In the Missouri case with the 84-year-old, if the kid outside his house was working the door handle of the storm door, would that reasonably be perceived as him trying to get in through the storm door? I think so.
it can't just shoot anyone.
You can't shoot the Amazon driver because he knocks on your door. You don't have a reasonable belief that that person is there to do you harm.
What if the Amazon worker starts working the doorknob of your door?
If what happened in Missouri happened here, you could also face charges the same way the suspect there is currently.
You can always potentially face charges. There's no, if you use or threaten force, there's no scenario where there's zero risk of you facing charges.
It would not cover you if it's just the proverbial or actual knock at the door from a salesperson or somebody that's lost and is coming to knock on your door.
Amazon does open storm doors all the time. They do. When your front door is closed.
The law also states
You're also wearing an Amazon uniform
if someone is walking away from your
and holding a package.
home, workplace, or car, you must stop trying to use deadly force once they are off your property.
They leave your property, they leave your home, then you've got to stop. You can't chase them off of your property. You can't get in your car and follow them and try.
Of course not, because then you become the aggressor, because they're no longer a threat if they're fleeing.
Shoot at them. That's not permitted.
The law also states you
Yeah, not a lot of gym memberships in these videos,
can't open
except for Chad.
fire on a law enforcement officer or bail bondsman who is doing their job at the time.
All right, this is another misstatement of law. Oh, what happened?
Shoot at them. That's not.
She's going to make a statement. The media woman is going to make a statement about when you can use force against law enforcement. Here we go.
Not permitted.
The law also states you can't open fire on a law enforcement officer or bail bondsman who is doing their job at the time.
All right, that's not correct. That's not correct. The question is not whether or not the law enforcement officer was doing their job at the time. The question is, as always, did you have a reasonable perception that you were being subject to an unlawful, imminent threat of deadly force harm? What if you don't know that it's a police officer and they're breaking into your home? Maybe they're breaking into your home for good reason. Maybe they have a warrant. Maybe they were told there's a kidnapping in place or some horrible crime taking place inside the home. So there's exigent circumstances. But if you don't know they're an officer, then you're privileged to treat them based on your reasonable perception. So the fact that in an absolute sense they're an officer, if you can't reasonably perceive they're an officer, you treat them just like any other home invader. And that would be lawful. Now, what the law does says, with these legal presumptions of defending your home, where you get that a legal presumption, it's legally presumed that when faced with that home invader, you had a reasonable fear of imminent deadly force harm. Most of those statutes have exclusions where if one of those exclusions is true, you lose the legal presumption. You don't lose self-defense. You still have self-defense, but it's not presumed that the elements are in place anymore. And one of those exclusions is commonly that the person you used force against was a law enforcement in the course of their duties. So you could still argue, hey, I didn't know they were a cop. They weren't in uniform. They weren't shouting police, whatever your narrative would be of why you didn't perceive they were a law enforcement officer. And you'd still be able to argue self-defense based on reasonable perception, but you would lose that special provision for highly defensible property. You would lose the legal presumption if it turned out that they were a law enforcement officer.
With your Verify Fact Check, I'm Megan Bragg.
Megan Bragg.
Innocent moments of.
Okay, that's it for Megan Bragg. So those are the three experts I wanted to share with all of you. All right, so now I'm going to start going through questions. If you're a law self-defense member, just put your questions in the chat. I'll get to those now. And if you're watching this live on YouTube or Rumble, your questions, in order to get answered, need to be a $5 YouTube super chat or a $5 Rumble rant, or become a law self-defense member. By the way, folks, if after hearing those three experts talk about use of force law, you're wondering if their ignorance of use of force law is common in the legal profession, including among prosecutors, the answer would be yes. This is a representative level of knowledge of actual use of force law, lack of knowledge, ignorance of use of force law within the legal profession. That's why law of self-defense exists, folks. It exists so we can consult to these attorneys who otherwise are competent in the 1,000 other facets of a criminal defense, evidence, criminal procedure. They're great. They're great at that. They're just not very skilled at use of force law. And that's why my legal practice exists, why it's a legal consulting practice, why we consulted these other attorneys to make sure they have the level of use of force expertise they need so their clients don't get railroaded by these crazy prosecutors. But we only provide legal consults to our law self-defense platinum members. If you're not a platinum member, we do not take your case. You do not have access to my expertise if you're not a platinum member, and we don't take outside consults anymore, effective last year, at any price. You can't hire us unless you're a platinum protection member. The good news is, right now we are having we just did a webinar this past weekend to promote our platinum program and offer a very, very attractive offer to the webinar participants. And it's proven so popular, we're going to extend it for 2 days. It was a 48-hour offer. We're going to extend it for 2 days for non-webinar people who were not at the webinar. And this is that offer. I'm not going to spend a lot of time talking about it because there's a URL you can go to learn more. But it's our law self-defense platinum protection coverage offer, the lowest cost we've ever charged for this. So it's 5 years of my guaranteed legal consult if you're involved in a use of force event. So your lawyer doesn't look like these people in court. So your lawyer has the expertise I bring to the table in your use of force case. 5 years of that coverage, which is normally $3,000 all by itself. Plus, we give you as a free bonus $3,000 of law self-defense educational content, essentially all our courses, our full day course, our defense of property course, defense against riot, looting, and arson course, how to choose a self-defense insurance policy course, multiple copies of our book in print, ebook, audio, video form, automatically included law self-defense membership, all of that. It's literally $6,000, $5,950 worth of value. For the next 48 hours, you can get that locked in for 5 years for less than $1 a day, 82 cents a day, folks. Guarantees you, first of all our instructional content, law self-defense membership, and 5 years of my legal expertise guaranteed if you're involved in the use of force event. And that's the only way to get my legal expertise, is to be a platinum member for 82 cents a day, folks. 82 cents a day. So your lawyer doesn't look like these experts. So if that's of interest, if you'd like to learn more, you can point your browser to lawofselfdefense.com/82 cents. And there are a variety of payment options and stuff like that, so you can spread it over time. But the net over 5 years is 82 cents a day. Folks, well, I don't know what to tell you. I'm offering 5 years of my legal expertise for 82 cents a day. Hopefully that's an attractive offer. Otherwise, what we just saw is the level of expertise you can expect. All right, let me turn to the questions. First on the member dashboard. And by the way, if you're currently a platinum member or a regular law self-defense member, we're happy to transition you over. Whatever deal makes the most sense for you is what we're happy to do for you. Let's see, law self-defense members. Yeah, I'm sorry about the audio glitches, folks. Sometimes I forget to go back. Jerry, law self-defense member, Jerry asked, do you ever attempt to engage these biased non-legal dummies to set the record straight? Do you think they want to have a one-to-one conversation with me? Do you think? No, they don't, folks. They run away. The cases where people don't run away are the unbelievably exceptional cases, like we recently had with Professor Marcus Funk, who was on the show, where I had critiqued one of his papers, his academic papers, and he reached out to me. And we had a wonderful conversation on the phone. We met for lunch. He came on the show. What a fantastic guy. But that is 1 in a million. He was not at all defensive. I mean, he had his own perspectives and views. We don't have to agree on everything, but he was more than happy to have a public discussion about those. That's a guy you have to respect. Most of these people, they know they don't know what they're talking about when they encounter someone who does. So no, they run away is what happens. Law self-defense member Chuck asks if I looked into the Texas cheerleader shooting. I haven't. All I've heard is kind of a general narrative that she apparently tried to get into the wrong car or got into the wrong car. Folks, there's a lot of carjackings. Especially that was in Austin. Austin is not, there's a lot of crime in Austin. I don't know what the driver was thinking. I haven't looked at all the facts, but if you're attempting to unlawfully enter someone else's car, it's likely to be reasonably perceived by them as you unlawfully attempting to enter their home. Dennis asks question, law self-defense member Dennis asks question, as many subject matter experts have a different view than you, do you sometimes question if you're not misunderstanding the law? You must be the crazy one. I would think that, Dennis, and I'm certainly open to that argument. But I look at the actual law. I read the statutes. I read the cases. So if I'm wrong, they'll have to show me in the law where I'm wrong. And I will happily debate anybody on these. And nothing would make me happier than to be shown that I'm mistaken. Because if you show me that I'm mistaken, I've just learned more. And that's where I want to be. I don't mind being shown that I'm wrong. I glory in being shown that I'm wrong because it makes me stronger at what I do. Again, I'm happy to debate anybody. Yeah, Dunning-Kruger in full effect, says law self-defense member Texas John. Indeed, indeed, indeed. All right, let me take a look and see if there's any super chats. By the way, folks, I mentioned in yesterday's show that we're changing how we're doing our content moving forward. For the last few months, it's been all public access. It's been on YouTube. It's been on Rumble. We're changing that. So we do 4 to 5 shows a week. Moving forward, 2 of those shows will be public. So we did a public one yesterday and a public one today. Wednesday and Thursday are going to be for law self-defense members only. And we're going to cover, I think I have 5 or 6 shooting cases, shooting events to cover over the next couple days, where we have the video of the shooting and we do a legal analysis of those. Whenever I do the shooting stuff on YouTube, I get demonetized. So I'm not doing that anymore. It's going to be members only content. So if you'd like that shooting analysis, you need to be a law self-defense member. And again, you can become a law self-defense member either by taking advantage of this 82-cent deal, that makes you a member, or become a member at lawselfdefense.com/join. So Wednesday and Thursday will be non-member content, or ordinarily will alternate, public member, but it didn't work out that way this week. And then I think on Friday, we're going to have platinum member only content. So we're going to platinum members. One of the benefits of being a platinum member is there's a platinum Q&A form on the website where you can submit your legal questions to me directly, and I'll provide you with, not legal advice, but an academic explanation of the issues that you're concerned about. And we do those typically on Friday shows moving forward. But Friday will be platinum member only content. Also, one result of this change is I think most of our public content moving forward is not going to be live broadcast anymore. It'll be live for Law Self-Defense members. But the 2 days a week that go to YouTube and Rumble will be recorded shows, which means I won't be taking questions, live questions on YouTube or Rumble any longer moving forward. So the super chat option, the Rumble rant option, those are disappearing moving forward. Just FYI. All right. Yeah, I don't really want to deal with YouTube or Rumble, to tell you the truth. We only do it to, it's a way of growing our law self-defense community. But what we really want is people in our community, not funneling money through YouTube, where YouTube takes a third of it anyway. All right, super chats. Let's see if there's any. Just one. David says $5 super chat. Thank you very much. Says MSM peddling misinformation. No way. Confession through projection at its finest. I certainly agree with that. And if there's Rumble rants, let me take a quick scroll. And it looks like there are not. All right, folks. Again, this 5 years of platinum coverage is the best offer we've ever made on our platinum program. 82 cents a day. You probably have that on the floorboards of your car. But it's up to you. I would urge you to go to the website at least and take a look. There's a little video there, that video right there, where we explain it in more detail. lawofselfdefense.com/82 cents is the URL for that. All right, folks. And with that out of the way, I will just remind all of you that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, for Law Self-Defense members, that will be tomorrow. For those of you who are not members, that'll be next week. Until next time, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe.